Does your company have model clauses for AI providers? And what are AI providers? Any technology supplier can become an AI provider since they might use AI to develop technology, for instance. What if I told you in this context that the European Commission is trying to help companies in this difficult situation on how to deal with procurements related to AI technologies? They built a toolkit that could radically change how we structure the purchase, sale, and deployment of artificial intelligence systems in both the public and private sectors. In this context, whether you are a public authority buying an algorithm to assess social benefits or a private company integrating AI into your customer service, these new clauses could soon become your best legal ally or your worst headache. I'm Giulio Coraggio, a technology and data lawyer at the global law firm DLA Piper. This is the podcast Diritto al Digitale, where we explore the intersection between law and innovation. And today we dive into the updated Model Contractual Clauses for AI Procurement, just released by the European Commission in the light of the AI Act that has come into force. So what are we talking about? The Model Contractual Clauses for AI Procurement were first introduced in September 2023 and just updated to reflect the obligations imposed by the AI Act. They are a practical modular contractual template, created to help both public buyers and private sector operators source and provide AI systems in compliance with the new regulatory landscape. So why is this important? Because under the AI Act, using AI isn't just about innovation. It's about accountability, transparency, risk management, and data governance. And when you put these requirements into a contractual relationship, things get very complicated, very quickly. That's where the model clauses come in. The model clauses are not a complete contract. Instead, they are a set of clauses meant to be integrated into a broader agreement, such as a software as a service license or an IT procurement deal. They do not cover general terms like intellectual property, indemnities, or governing law. Instead, they focus purely on AI-specific obligations under the EU AI Act. There are two versions of the clauses. A full version for high-risk AI systems, think facial recognition, credit scoring, or recruitment tools. And a light version for non-high-risk systems, but still aligned with the key AI Act principles like transparency and technical documentation. Both versions are supported by an explanatory guide, use case examples and templates for data governance and compliance documents. The model clauses cover five main areas. Number one, AI system compliance, defining the legal and ethical standards the system must meet. Number two, supplier roles and responsibilities, establishing who does what in terms of risk, transparency, and compliance. Number three, data governance, who owns the data, who can access it, and how it's used. Verifiability and traceability, how the AI system will be audited and monitored. And number five, cost allocation, who pays for what, especially when changes are needed to ensure compliance. In a world where AI is often a black box, these clauses aim to make the contractual relationship much more transparent and accountable. Although the model clauses are targeted primarily at the public procurement, private companies should not ignore them. They can and probably should be adapted for a B2B AI transaction as well. But there is a catch. In the private sector, contractual negotiation is a different game. AI vendors, especially the big ones, often hold a stronger bargaining power. Many operate on standard terms and conditions and offer AI as a service models where custom clauses are hard to integrate. Still, even if you can't impose them wholesale, borrowing language or principles from the model clauses can help companies show regulatory readiness and reduce legal uncertainty, especially if things go wrong and there is a dispute. Let's be honest, the practical adoption of the model clauses may face headwinds. Why? Because of the balance of power is rarely in favor of the buyer. Many AI deployments today happen via standardized pre-built platforms, often open source or proprietary systems with short-form licensing models. In this context, it's hard to negotiate basically anything. But if you are a regulated entity, or if your AI use case impact human rights, consumer rights, or safety, regulators will expect more. Adopting or at least aligning the model clauses might not be optional for long. So, what should companies do? Number 1, map your AI supply chain. Identify where you are buying or building high-risk systems. Number 2, compare existing contracts to the model clauses. Are you covering compliance, data governance, audit rights? Number 3, adopt the model clauses to your industry context, adapting them to your specifics. Number 4, train your procurement and legal teams. They need to understand not only the clauses, but the risks they are meant to integrate. Above all, view these clauses not as a bureaucracy, but as a competitive advantage. If your business can prove it has responsible AI contracts in place, you are not only mitigating risk, but you're building trust. Also, what we are doing for clients is to create ad hoc model clauses relating to AI procurement for them, specific on their business. So apart from the model clauses drafted by the European Commission, what we do for our clients is to do something that is more tailored on their business, on their peculiarities of their operations and of their specific needs. So both versions, the one approved by the European Commission and those customized by us, are not magic. They won't instantly solve the complex power dynamics of today's AI market, but they are a starting point, and perhaps the most structured one we had so far, to bring legal certainty into an area dominated by technical complexity and ethical gray zones. So what do you think? Are these clauses something you'd actually use, or are they just another layer of red tape? Let me know. I'd love to hear your views. Write to me at giulio.coraggio@dlapiper.com, and if you found this episode useful, subscribe to Diritto al Digitale. Turn on the bell so you don't miss upcoming episodes, and leave us 5 stars on Apple Podcasts or Spotify. I'm Giulio Coraggio, this is Diritto al Digitale. Arrivederci.